threats of force. We're in a period of overstretch. The trillions of dollars that we're spending on the troops we have overseas really do need to be brought home. There's no doubt about that. And so the real question is, why don't we use these diplomatic resources to build structures which could be called law to give us some kind of certainty in the world? Why don't we re-engage with the Kyoto Protocol? Why don't we re-engage with the Law of the Sea Convention? Why don't we re-engage? Why don't we exert our sovereignty through diplomatic processes and agreements? Now, that's a strategic question for either presidential candidate. We've seen the limits of our hard power. That's my point. We've seen the limits of our hard power. And we've seen the limits of our unilateral power. And frankly, the unilateral hard power is not enough. And so now we need to start exercising some other kinds of tools, and they include diplomacy, legal institution building, compliance with international norms, agreement on common principles, a global attack on global problems, all of which have been pushed to the background in the last 7 years.
Thank you, Dean Koh, for being here at the City Club of Cleveland. I think during your prepared remarks, I heard you refer to the possibility of there being a commission or some organization to investigate past abuses by the United States. If you were the next president, what considerations would you take into account concerning possible pardons?
That's why you have a commission. I mean, to be honest, I think you have a 9/11 commission type of activity to look into it, a truth commission is. You know, in other countries, when there are human rights abuses, we call on them to have truth commissions. El Salvador, Guatemala. My job in the government was urging these countries to face up to what they did. It's a way of getting past their past, Argentina. Now, the fact of the matter is, for this to be done, it ought to be done on a bipartisan basis. I mean, look at Abu Ghraib. For all of the reports on Abu Ghraib, there is yet to be any significant punishment administered. When I saw the people standing like this, the man with the hood, the famous picture from Abu Ghraib, the first thing that came to my mind, and I visited torture dens all over the Middle East and in Eastern Europe, guess what? The 19-year-old private from West Virginia did not think of that technique. They were trained. That's an established torture technique. Somebody trained them. Who trained them? Did they do that consistently with the Uniform Code of Military Justice? If not, they should be punished. Now, somebody has to look into this first and make a set of recommendations. I agree with you that the question may ultimately be one of pardon, but it's not the question about whether we know the truth. So I'll give you another example. A graduate of our school, who I admire in many respects, Attorney General Mukasey, he's asked, is waterboarding torture? He says, as Attorney General, I don't want to answer that question because there are people in the government who may have committed this, and we have to look into those cases into the future. Now just imagine, if you're the Attorney General of the United States and you're asking, is burglary a crime? You say, I can't answer that question. Why? Because if people in the government have committed burglary, I can't give that answer. The answer should be, I'm the Attorney General of the United States. I speak for the rule of law. Waterboarding is torture. That doesn't mean that if it's investigated, prosecuted, and convictions obtained, that certain people shouldn't be pardoned because of some extraordinary circumstance. But I will get to the truth, figure out who did what, determine who should be punished, and determine for whom pardons ought to be recommended. Not act as if the offense is not an offense. And that, I think, has been the violation of the rule of law that's occurred. You cannot make decisions about who to be punished, about what should be punished based on who might be punished. And if you look at the famous torture memo, why was the torture memo written? Look at the first footnote. Under the U.S. War Crimes Act, someone who tortures someone to death can be sentenced to the death penalty. And what we now know from numerous accounts is that at the time that memo was drafted, people were being held who were being tortured significantly by U.S. officials. I'm sure those U.S. officials went and said, if this person dies, will we get the death penalty? We need a grant of immunity preemptively by a legal opinion. And that's why the opinion was written. And more than that, that opinion was written never to be read or seen. And when I was in the Justice Department, in that very office, the Office of Legal Counsel, the one rule we had is, does it pass a straight face test? If it appeared on the front page of New York Times, would you stand by it? This one, as soon as it became public, they withdrew it because it was patently false. Among the things it says is, to torture somebody, you have to cause pain close to failure of a bodily organ or serious injury or death. Well, I'm sorry, you know, torture, putting fingernails under the bamboo shoots under your fingernails, or holding you upside down in strange positions might not kill you. In fact, that's what we said when we called Saddam Hussein a torturer. We listed a set of things he had done, none of which met our own definition of torture under the torture memo. And then, amazingly, we said, someone who tortures under the direction of the president is acting under the commander-in-chief power. That, to me, is essentially adopting the just following orders defense in Nuremberg. So these are grotesque distortions of our law. These are stains on our law. And it's very important for a country committed to the rule of law to acknowledge these errors. You know, we've made errors before. Korematsu was an error. We acknowledge that error. It's not a happy moment, but we now wouldn't do that again. Plessy versus Ferguson, that was wrong. We shouldn't do that again. But unless we're willing to take these things on and acknowledge them as legal violations, then whatever happens to the particular perpetrators is a matter with regard to case by case.
Dean Koh, for those of us who don't practice in the field of international relations, but who followed the Hamdan case, I, at least for one, find it very confusing, the interplay between the victory in that case and then Congress legislating around it. Can you sort of, in a very quick way, bring us up to date about where the bidding stands in that whole Guantanamo process? Thank you.
Yes. Question one, why did we need military commissions in the first place? Answer, we didn't. Nobody said that we needed to have military commissions because nobody fully investigated whether these cases could have been tried in civilian courts. As I said, a recent study by prosecutors says that 120 cases were properly tried in civilian courts with classified information, no breaches, and you know, they're difficult cases, have no doubt about it, but we have top-notch prosecutors. Now, the fact of the matter was, as is now well known, there was no plan to have military commissions, but there was a discussion about how to draft an order. At a certain point, a process took place in the White House in which the order was drafted in one day by a couple of lawyers and just issued. It was not seen by the Secretary of State, the National Security Advisor, the Office of Legal Counsel, or any responsible legal official before it was released. Now, that military commissions order shocked everyone. Lawyers across America protested. It gets to the Supreme Court, and it was struck down. Who's surprised? I wasn't surprised. Now, what was the basis on which they struck it down? It wasn't authorized by the Constitution. It wasn't authorized by a statute. And the most important point, if you're going to try people, you should try them before regularly constituted courts. That was the word used by the key opinion. The Uniform Code of Military Justice and the Geneva Conventions require that it be a regularly constituted court, not an ad hoc court. Now, the government originally said, this is the most important case of all time. We must win it. After they lost it, they said, this is an unimportant case. All we need to do is pass a new law in which there's legislative approval for military commissions. And those were the hearings I attended. Now, those hearings started this way. The Supreme Court has told us that the military commissions, to be lawful, should look as much like regularly constituted courts as possible, with only minor variations. Therefore, why don't we start with the Uniform Code of Military Justice and design a system that looks like that? But before the midterm election, they just adopted a new set of rules which looked nothing like a regularly constituted court, and then, to boot, stripped habeas corpus.